A trademark infringement defense is a legal case brought by a defendant to prove they did not infringe on someone else's, the plaintiff's, trademark. Basically, trademark infringement is the unauthorized use of a trademark or service mark on goods or services that compete or are related. It's important to note that infringement doesn't need to be an exact replica or copy, just similar enough to confuse the average consumer. This is especially an issue when both marks share the same market and thereby can be seen as related. There are 4 primary defenses to claims of trademark infringements. The first is Doctrine of Laches. Laches is an unreasonable delay by the plaintiff in bringing a claim. When you assert a defense of the Doctrine of Laches, you're asserting that the other party did not bring the claim quickly enough and is out of time. The doctrine of estoppel has 3 main elements: position of authority assumed by the defendant's submission to and reliance upon that assumption by the plaintiff, injury suffered by the plaintiff as a direct result of submission and reliance. Unclean hands is only invoked by the court when a plaintiff is otherwise entitled to relief, but acted so badly with respect to the claim of infringement that the public interest in punishing the plaintiff outweighs the need to stop the defendant's illegal conduct. Fair use, or collateral use fair use, is probably the most common defense raised to trademark infringement claims. You often hear it quoted in parody cases, although fair use doesn't apply when the claimed parody is used to promote a competitor's goods or services. Trademark infringement defenses are needed when someone who owns the rights to a trademark sues another person for attempting to use their mark, or one that is substantially similar to the trademark in question. Why is a trademark important? It's a way to identify that all goods bearing the mark come from the same source. It's a guarantee of uniform quality, and it's also a form of advertising. Every trademark has some ranking of strength, whether it's weak or very strong. The range provides insight into the product. If it's suggestive of the goods, it's the weakest, whereas made-up terms or unrelated marks make the strongest trademarks. When trademark infringement is suspected, a trademark owner brings a lawsuit against the suspected infringement user or defendant. Lawsuits may require the defendant stop using the trademark in question, and it may also award damages for the wrongful use of the trademark. The plaintiff may bring the action in either state court or federal court if the trademark is protected under the Lanham Act, which applies to both registered and unregistered trademarks that are used in commerce streams, where Congress may oversee regulation. Deadlines and regulations for bringing a trademark infringement case are very strict and detailed.